Hello, everyone. I am very excited to welcome you to today's discussion about some of the key cases before the Supreme Court this term. My name is Laura Safdie, and for the next hour, we'll be speaking with two leaders in Supreme Court litigation, Tom Goldstein and Kevin Russell, attorneys with the Goldstein and Russell Law Firm and authors for SCOTUS Blog. Because of the number of viewers we have today, we can't have two-way audio, so we'll ask that if you do have any questions, which we encourage you to share for Tom and Kevin, please tweet us at CaseText or email us at support@casetext.com. You should see the Twitter handle on the screen here. We'll be monitoring those questions and we'll answer as many as we can. Just a note that this program has been approved for 1 hour of CLE ethics credit in 19 states, including New York, California, New Jersey, Pennsylvania, Texas, and others, and credit is pending in the remaining states. To see a list of the states that have been approved for the webinar, please visit casetext.com/CLE. If you are seeking credit, you must attend the entire webinar. Your attendance will be tracked through the GoToWebinar application that's hosting the program. I'm going to take just a minute to introduce our panelists, though I'm sure most of you are very familiar with their work. Tom Goldstein has served as counsel to a party in well over 100 merits cases at the court and has been counsel on more successful petitions for cert over the past decade than any lawyer in private practice. Tom is the founder and publisher of SCOTUS Blog, which we appreciate very much for their valuable commentary and analysis of Supreme Court decisions. Kevin Russell has argued 12 cases, at least as per the bio that I've seen most recently, but that might be out of date, in the court, and has served as counsel in 50 others. Kevin has been counsel on more successful petitions for cert in the past decade than any other lawyer in private practice, apart from his partner, Tom, who is sitting next to him. Both Tom and Kevin are instructors in the Supreme Court Litigation Clinic at Harvard Law School, and both are regular SCOTUS Blog contributors. I am extremely honored personally to help host this conversation, along with the American Constitution Society, the Federalist Society, SCOTUS Blog, and CaseText. Please join me in welcoming Tom and Kevin. So to get us started, I know there's 4 or 5 cases we're hoping to cover, and then we're going to leave some time at the end to talk about some broader trends at the court this term. Tom, do you want to kick us off with Espinoza?
Sure. And so what Kevin and I are going to do is cover essentially the second half of the docket of the major cases of the term. Of course, we already had part 1 of our ongoing review of the term, and that's available online. People can look at that earlier video that Sarah Harrington and I did. The first thing that we're going to do is dive into religion, and we may end up coming back to it later. The biggest religion case of the term is called Espinoza, and it really deals with the intersection between 2 closely related provisions of the Constitution, the Free Exercise Clause and the Establishment Clause, which are in some ways in a little bit of tension. One guarantees the right of individuals to the free exercise of religion, but at the same time, it guarantees that the government won't establish a religion. And so the dilemma arises when you're dealing with governmental programs that provide aid to religious organizations, and that is that aid doesn't need to be provided on a non-discriminatory basis and therefore allow for the free exercise of religion. But if it does that, does it in turn establish a governmental religion in some sense? And where do you draw that kind of line? The case arises in a recurring context in the law, and that is scholarship programs for religious schools. So this is, the particular context is around 40 different states have state constitutional provisions that prohibit the state government from giving aid to a church or to a religious school. And about 20 states have programs that provide for aid and scholarships that can end up going to religious schools. And the question is, how do the state constitutional provisions interact with the state law? And how do the state constitutional provisions interact with the federal Constitution? So here you have a program in the state of Montana, and it says that there'll be a $150 tax credit for anyone who contributes money to certain private scholarship programs. Now, those scholarship programs can be used at any private school in the state of Montana, but most of the private schools in Montana are religious schools. So if I were to donate $100, the state would match it, and then the scholarship funds under the state law would be distributed to the various schools, which would in turn give them to students. So a challenge was brought to the Montana program, alleging that it violated the Montana state Constitution's prohibition on providing aid that would go to, directly or indirectly, to a religious school. And it does seem kind of on its face that this would be a form of aid. It would be used for the educational programs in the religious school, and the Montana Supreme Court agreed, and it said that it was unconstitutional. But the state Supreme Court said, well, look, if we were to recognize that there would be a problem just saying that the aid could only go to non-religious schools. And so what it did is it struck down the aid program entirely, so that the scholarship matching funds are not available in any form for any private school. The case was then petitioned by the plaintiffs, who are the parents of some students in the schools, and religious schools, to the Supreme Court, which agreed to hear the case. And it arises against a relatively recent case of the court called Trinity Lutheran. So in Trinity Lutheran, the court considered a program that provided for aid to redo school playgrounds. And the state in Trinity Lutheran had said that that aid couldn't go to a religious school because it would in effect be, the state giving aid to a religious institution directly, and it would be establishing a religion. And the Supreme Court said, no, this is really has nothing to do with a religion. We're talking about playgrounds and playground surfaces. And the Supreme Court, in invalidating the program in Trinity Lutheran, said, but we're not going to decide what the rule would be when there would be prohibited discrimination involving actual aid that would advance the religious mission of the institution. The rubber hit the road, if you will, in the Montana versus Espinosa case, where there the money is really going much more directly to the religious schools programs. And the case has already been argued this term, and in the course of the argument, there were two issues that were discussed principally. One is, as is often the case when you get to the Supreme Court, there's a real discussion of standing and mootness and those sorts of things. And the issues here are that the money that's involved comes from comes from the state based on donations that are made by private individuals, and then the scholarship money goes from the state to the schools. But the plaintiffs here are the parents of students. So they're neither people who contribute money that is matched by the state, nor are they the institutions, the schools, that receive the state money. And so the question was asked at oral argument, particularly from the more liberal justices that are more hostile to the claims, is there standing on behalf of the parents here? Should the lawsuit instead be brought by the schools or by donors to the program? The second question that was asked is essentially one of mootness, and that is, well, your claim is one of discrimination, but there is no discrimination now because the way that the state courts resolved this under the state constitution was to prohibit the program entirely. And given that the program doesn't exist anymore, so that it isn't a situation where money is being given to non-religious schools and rather than to religious schools, in the absence of discrimination, is there any constitutional problem whatsoever, given that everybody agrees under the Free Exercise Clause and the Establishment Clause that the government could decide not to provide any scholarships at all. But in general, it seemed after the oral argument that those questions were going to be resolved in favor of the plaintiffs, and the lawsuit was going to go forward. As to the merits of the lawsuit, well, the backdrop of the plaintiffs' claims is that these state constitutional provisions, in their view, which are called so-called Blaine amendments, are rooted in anti-Catholic bigotry. That there was a time in the country where a lot of these state constitutional provisions were added, and it was intended to try and prevent the state from giving aid that would benefit Catholics and Catholic institutions, and that the plaintiffs tell a story about how this is all rooted essentially in religious animus. And in addition, they say that what you have to do is look at the state constitution, not the result of the application of the state constitution, and the state constitution clearly does discriminate as between aid to non-religious schools and to religious schools. The state's arguments, in addition to the ones that I've identified already so far, do get to the idea that, look, the state should not be giving money that goes to core activities of a religious institution, including a religious school. And that's where the action is, and where everybody is very, very interested, particularly with respect to the change in the Supreme Court's composition and it becoming even more conservative after Justice Kennedy's retirement. because while the conservative Supreme Court has had an ongoing program to move the law to the right in a variety of areas, it didn't actually get very far when it came to the Free Exercise and Establishment Clause, because Justice O'Connor and Justice Kennedy weren't very active in those areas, unlike a lot of others. But now with Justice Gorsuch and Justice Kavanaugh on the court, it seems more likely that there is more sympathy to the claims of individuals and organizations that want to lower the wall separating church and state and make it more possible for the state to provide aid to institutions broadly and not exclude religious institutions. And that seemed to be where the oral argument was going. It's not entirely clear. Justice Gorsuch didn't ask many questions. The Chief Justice did ask questions kind of on both sides, as he often does. But I'd say the betting money is, given that it looks like the Supreme Court will get to the merits of the case, that the court is going to issue some kind of ruling that these state constitutional provisions and their application in this kind of context does violate the Free Exercise Clause, and that there can't be discrimination in aid programs like this. Now, then questions will arise, well, how far do you go? So, for example, states, of course, fund public education, but they don't fund private religious education. And so where do you draw the line in terms of, okay, you can't discriminate within the body of private schools? And those arguments will be pushed further and further by religious conservatives to see how far the Supreme Court is willing to go. But Espinoza does shape up as likely being a really landmark decision in the area of religion, and that where it is that you identify this balance between the free exercise and establishment clauses.
Thank you. That was a really, really good overview. It sounds like your assessment is that the standing issue is likely to be resolved in favor of the plaintiffs, but it definitely struck me when attorneys representing the parents argued in oral argument that the harm that established standing occurred when the Montana Supreme Court issued its decision, quote, mistakenly believing that the state constitution's ban on aid for religious schools was proper under the U.S. Constitution. What do you make of that argument? Can standing be established solely through the ruling of a lower court, even if, for the sake of argument, that ruling did misconstrue the U.S. Constitution?
Yeah, I think that it's very likely that the Supreme Court would hold that we look at the state of the law in the state after the state courts are done with it and have construed it. And the way that, including the process of how the state courts have construed it. The state, of course, says you should look at it, the end result here, in which there's no discrimination because the aid program doesn't exist at all. Right. But yes, I think that the justices are going to be willing to look at the application of the state constitutional provision and say that that is, in effect, a form of discrimination that has hurt the students who are represented here by the parents.
So let's assume it does get to the merits and it does go the way that you seem to think it's going to go. What would that mean for our understanding of the practical bounds of the separation of church and state if essentially a state can be forced to underwrite religious education with taxpayer dollars? Well, of course, the plaintiffs here would say that the state isn't being forced to do anything. It's just in terms of subsidizing religious education or religious institutions, other than to be neutral about it, that if it's going to make a legislative decision, which Montana did, to create programs like this, that they have to be available both to religious schools and to non-religious schools. And if the state decided not to have any kind of aid program whatsoever, then that would not raise a constitutional question in all likelihood. That doesn't mean that the case wouldn't be earth-shaking, because there are lots and lots of times that the government does provide aid to private organizations, tax breaks and tax credits, direct aid and all those sorts of things, and does try and stay out of the business of giving money to churches, for example, and church schools. And that is the result of a project, dating back several decades of the Supreme Court to identify this wall separating church and state and making it pretty high and pretty firm. So nobody really knows where this would end. Do I personally think that there's a majority in the Supreme Court that would be willing to say that because the state provides public education, it has to fund private religious education? I don't. There might well be, a couple of members of the court who read the Constitution's free exercise provision so broadly, but
but I can't imagine that there is a majority on the court for that. I think that there is a desire to get rid of some of the legacy of kind of the Warren Court, early Burger Court's views on the Establishment Clause, to make it easier for a state to conclude that it can neutrally give aid. But I don't think that there's a majority on the court for kind of a radical reworking that equates churches and church schools with public institutions more broadly.
So you don't anticipate that this could lead to a decision that would allow, considerable public funding diverted from public education?
Well, there's a difference between allow and compel. Do I think it would allow it? Sure. Do I think that there are state legislatures that are quite conservative, that are quite sympathetic to religious education, that think that religious education, when expanded, provides pressure on public schools to perform better, all those sorts of things. So a ruling like this one, which is in effect going to invalidate the state's view that it can't, treat the religious and non-religious institutions differently, nonetheless will, I think, send a strong signal to more conservative state legislatures that they can give direct aid. Now, obviously, or pretty obviously, the state couldn't have a program that's like, we're just going to fund religious schools and not other private schools, because that would be discrimination in the opposite direction. I don't think the Supreme Court would allow that. But in a state like Montana that has principally religious private schools, and lots of other states that have lots of religious schools, I think state legislatures will take that signal and provide a lot of aid that so far has been regarded as prohibited as unconstitutional.
Thank you. Very, very interesting. We'll obviously watch that closely. Kevin, do we want to turn it over to you and talk about the CFPB case?
Sure. So this is a case, the question is, does the structure of the Consumer Finance Protection Board violate separation of power principles? Principally because it is headed by a single director who is removable by the president only for, quote, inefficiency, neglect of duty, or malfeasance in office. So he's only removable for cause. The president can't remove him just because he doesn't like what he's doing or he wants to put his own person in. And the second question on the case is, if the court finds that it's unconstitutionally structured, what's the court going to do about that? What's the remedy? So as a bit of background, the CFPB was created in the aftermath of the 2008 financial crisis after Congress conducted a study and determined that the consumer protection function of the federal government in this space was too dispersed among a variety of agencies to be effective, and so they consolidated all that power within the CFPB. It has some kind of quasi-legislative responsibilities. For example, it enforces a law that says it's illegal to engage in unfair, deceptive, or abusive practices with respect to consumer finance. It's a very broad command, and the CFPB is given the power to interpret it and to issue regulations saying what that means in particular contexts. It also has enforcement authority. It can bring lawsuits. It can conduct investigations, including by sending what are called civil investigative demand letters, CIDs, which is one of the things that's at issue in this case, which is similar to a subpoena, requiring a regulated entity to provide the agency information it needs for its investigation. Most importantly, for purposes of this case, Congress created it with this single director who has this protection from removal, and in the same sense that there are a number of other independent agencies within the federal government, the Federal Election Commission, for example, whose members are not removable except for cause. So what happened in this case was the CFPB, which has jurisdiction over other entities, including consumer debt settlement companies, and they are subject to what's called the telemarketing rule. It's not particularly important for this case to know what that means, but it is a rule that they thought that a particular law firm that was engaging in debt settlement services was violating. And so the CFPB issued one of these civil investigative demand letters to the law firm, and the law firm resisted it, ended up in court. And the law firm said, among other reasons that it didn't have to comply with it, was that because it was issued by an agency whose structure violates the U.S. Constitution. The District Court and then later the Ninth Circuit rejected those challenges to its structure. The Ninth Circuit based largely on a decision from the DC Circuit earlier that had rejected a similar claim, a similar challenge to the structure of the board, which we will return to in a minute. And then something interesting happened. So while all of this was going on, well, let me back up for a second. So when President Trump was elected, the head of the CFPB was a man named Richard Cordray, who'd been put in that office by President Obama. And one of the interesting features of the CFPB is that the director serves 5-year terms, which guarantees that the director is going to end up spending at least some of his or her time working for a president that didn't appoint him or her. And in this case, Cordray, being appointed by a Democrat, was not particularly popular with the Trump administration, which wasn't happy that they weren't able to put their own person in. Nonetheless, the CFPB in this particular case went ahead and pursued the subpoena, the CID, and defended the constitutionality of its own structure in the lower courts. By the time the case had gotten through the Ninth Circuit, however, two things of relevance happened. One is that Cordray had left, and the Trump administration had put in their own people who took the position that the law firm was right, that in fact the structure of the CFPB is unconstitutional. And second, once the case got to the Supreme Court level, when the law firm filed a cert petition, representation decisions in the litigation were taken over by the Solicitor General's office, which is the unit within the Department of Justice that handles litigation in the Supreme Court on behalf of the federal government. And the Solicitor General took the same position as the new folks at the CFPB and told the Supreme Court, yeah, we agree, the Ninth Circuit was wrong. The structure of the CFPB is unconstitutional. It unduly inhibits the president's ability to fire the head of the agency at will, and urged the Supreme Court to take the case. Interestingly, the court took the case, even though there wasn't any division in the lower courts over whether on this question. Most of the cases the Supreme Court takes in order to resolve, so-called circuit conflicts, where courts of appeals have disagreed about the right answer to an important question of federal law. This is certainly an important question, but there wasn't a disagreement because the Ninth Circuit and the DC Circuit agreed on the answer, but the Supreme Court took the case anyway. And what they did is what they often do in a circumstance like this, where both parties before them agree that the Court of Appeals got it wrong. And that is, they appointed an amicus to defend the judgment below. In this case, they appointed Paul Clement, who was the Solicitor General under G.W. Bush, a very respected member of the Supreme Court bar. And it fell upon him to defend both the Ninth Circuit's decision and the constitutionality of the board. In the Supreme Court, the law firm and the government made arguments that were largely parallel with respect to the merits, and they diverged then with respect to the remedy. With respect to the merits, they made an argument that is pretty straightforward from first principles. They say, look, Article 2 of the Constitution vests the entirety of the executive function in the president. He has to be in control of the people who are executing those functions within the government in order to fulfill his constitutional obligation to see that the laws are faithfully executed. Not being able to fire somebody unduly interferes with that ability to exercise a constitutional responsibility. And therefore, this structure, one would think, just looking from first principles, is unconstitutional. The difficulty the government and the law firm have is that the Supreme Court has this decision called Humphrey's Executor, which was decided in 1935 in the midst of the New Deal, and at the end of the conflict between the president and the Supreme Court over his authority to create the New Deal, which entailed creating a bunch of new agencies, including the Federal Trade Commission. And the Federal Trade Commission, much like the CFPB today, was given responsibility for enforcing and elaborating on some pretty general laws, including laws that forbid unfair trade practices. And it also had some executive responsibilities for bringing lawsuits, enforcing the law. And it had a leadership composition that was similar in the sense that it had a board that could not be fired except for cause. Now, the one difference is that the FTC has a multi-member board, and what's unusual about the CFPB is it has a single director who's only removable for cause. And in Humphrey's Executor, the Supreme Court heard another similar separation of powers challenge to the Federal Trade Commission and said it was okay. They said this largely because they viewed the Federal Trade Commission as not a purely executive entity, that it had these responsibilities that the court viewed as quasi-judicial, quasi-legislative, in addition to its executive responsibilities. And as a consequence, it held that the Constitution doesn't require that that agency be completely under the control of the president, and that it was okay for the president to be limited to replacing them as their terms expired with the consent of the advice and consent of the Senate. So the government and the law firm in this case have set about to either distinguish Humphrey's Executor or to persuade the Supreme Court to overrule it if it has to. They say that Humphrey's Executor is different because this has a single director, which they say is importantly different because when you have a multi-member board, it's much harder for that agency to act arbitrarily. The other members act as a check on each other. Whereas if you have a single director who can do what he wants, you're kind of left at his or her mercy. And they also say that it's, among other things, that it's easier for an industry to capture an agency that has but a single person as its head. And as a consequence, a single member agency is much more problematic in terms of what the separation of powers is supposed to be doing for us, which is protecting people from overreaching by the federal government. But they both say, look, if that doesn't convince you, Supreme Court, then Humphrey's Executor is just wrong. It was decided at a time where the court wasn't giving sufficient attention to the first principle kinds of things that we argued about that I discussed earlier, and that it doesn't accord with the function of separation of powers. Both, then, at the point at which the government and the law firm diverge is what to do about it if the court decides that the case, that the structure is unconstitutional. The law firm says, number one, actually don't decide anything other than the fact that this CID is invalid and unenforceable. Don't go on and figure out whether the entire agency has to be stricken or if there's some other limitation that you have to impose in order to remedy the violation. Just do this very narrow thing of saying we don't have to comply with the CID. But they say, if you don't agree with that, well, then we don't think you can save the agency. You need to strike the whole thing down and let Congress go back to the drawing board. In part, one of the reasons they say that the court should either do that or just not reach the remedy issue at all, they think that Congress, if given the choice, would do the thing that it is most often done with independent agencies, which is create a multi-member board, which the courts can't do. That would require rewriting the statute in a way that courts aren't authorized to do. The Solicitor General takes a different view. They say that the court should strike down only the provision that limits the termination of the director for cause. And they say that that's severable and that's a modest way to deal with the constitutional problem, and it restores the president's power over the agency. Paul Clementa's amicus for defending the judgment below makes a couple of bodies of argument. The first is a series of attempts to get the court not to decide the case or not to decide this issue. He argues that this isn't an appropriate case because there's no reason to think that what's being complained of here, this civil investigative demand, is related in any way to who is leading the agency or how many members or whether that person can be fired for cause or not. And he says that the court should only decide this kind of issue in a case in which the president has actually tried to fire somebody at will without cause, and you can be litigated in that concrete context. Assuming that the court doesn't buy that and then turning to the merits, the amicus argues that, look, nothing in the Constitution addresses the removal power of the president. And in fact, the Constitution, by its terms, gives an awful lot of power to Congress to set up the federal government, to create agencies. And this is part and parcel of that authority. And in addition, Congress has been creating independent agencies, and the Supreme Court has unanimously been approving of them for a very long time. at least since the decision in 1935 in Humphrey's Executor, but with respect to individual officers, even before that. And amicus points out that, look, overruling Humphreys now would really change a lot of the way the government, how the government does business. He says a third of the federal agencies that are currently in existence could be affected, for example. And finally, and in the same vein as the argument that the court shouldn't decide this, he said, look, even if the court thinks that there's a serious problem here, the better way to deal with it is by giving a broad construction to what counts as the kind of inefficiency, neglect of duty, or malfeasance of office under which the president is authorized to remove the director. And that is a way of giving the president greater oversight authority than some might think he currently has without striking down the entire statute or calling into question the constitutionality of a range of other agencies. So this case hasn't been argued yet. It's going to be argued in March, on March 3rd. At this point, my kind of reaction is the fact that the court took this case without a circuit split, that the government is agreeing with the law firm are bad signs for the agency. I think is also facing a court that has been very protective of the president's prerogatives in this area. And we know, for example, what Justice Kavanaugh thinks. We recall that the Ninth Circuit affirmed largely for the reasons of the D.C. Circuit's prior decision. That was a decision that, an en banc decision that overruled a panel decision that Justice Kavanaugh, then Judge Kavanaugh, had written, in which he said that the structure of the CFPB was unconstitutional and that the way to remedy it is to sever the for-cause provision. So the challengers have at least one vote pretty clearly in the bag, and they likely have several others among the conservatives who, in recent cases, have taken very seriously these sorts of limitations on the president's removal authority.
Thank you. That was a really helpful overview. On the point of Justice Kavanaugh's dissent from the en banc decision, do you think his opinion will hold special weight given his background in this issue?
I think probably not. I mean, he will, having thought about it a lot, he will be a voice that is given a lot of respect. But, I mean, to be honest, there are a lot of justices on the court who came from the D.C. Circuit and have a lot of experience in this area. And they're a bunch of smart folks who know what they think. I don't know if it'll have undue weight.
Understood. So coming from the other side then, I thought it was interesting that several Democratic senators who were personally involved in the creation of the CFPB submitted an amicus brief, explicitly laying out the congressional intent behind structuring the CFPB the way that they did. They said it was to avoid corruption and industry capture of the regulators. And so I'm wondering if, your perspective at all is that this congressional intent argument, particularly coming from the senators actually involved in drafting and creating the CFPB, will hold any weight with this court?
In short, no. I mean, the court in general doesn't care what legislators think about their laws, and they particularly aren't going to care what they think on a constitutional question. There are some members of the court who will be sympathetic to the view that independent agencies serve an important purpose. And the prior case that came up in this area involved ALJs and the SEC, or a case in this area. And Justice Breyer, for example, is very concerned that making them too accountable to the president calls into question their ability to be impartial in particular cases. So somebody like him, I think, is going to care a lot about these practical issues, but there are others on the court who either don't care that much, they're much more concerned about being faithful to the doctrine and to the kind of understanding at the founding, or they think that, look, there are various serious countervailing practical concerns on the other side about having agencies that are accountable pretty much to no one, because there's no congressman you can write to, no president whose office you can call to get relief if that agency is acting badly.
Thank you. All right, so we are moving swiftly along in the hour, so why don't we transition to the tax return case?
Sure. So we have here a series of cases in which the Supreme Court has decided to address when it is and how it is that you can subpoena records of the president. And the general theme of these cases, or the backdrop of these cases, is the effort to get documents that relate to the president and his private information, but not information directly from the president and not relating to the president's ongoing duties as president. And for that reason, nothing that is privileged regarding the operation of the presidency. So 2 of the cases arise from the Second Circuit and 1 from the DC Circuit. The first case out of the Second Circuit is called Trump versus Vance, and it comes in the criminal context, whereas the other 2 are civil cases. The criminal cases involves the Manhattan District Attorney, who issued a subpoena to Mazars, the accountants of the president, seeking a variety of financial records related to the president, members of the family, the Trump Organization, and the like. And the general context is an investigation by the Manhattan DA about the hush money payments by the president to women who made accusations against him, and whether there was criminal activity in general in a variety of ways that are possible, including how it is that the money was sent and how it is that the payments were hidden. So the subpoena was issued to Mazars, and the president went to district court, which held that the case had to be litigated in state court because it was a state grand jury subpoena, but in any event that there was no immunity from the subpoena. That was then appealed to the Second Circuit, which agreed, but only on the merits, rejecting the district court's view that such a claim couldn't be brought in federal court, recognizing the important interests of the president in being able to enforce federal protections, should they exist, from burdensome subpoenas. But the Second Circuit said, look, this doesn't relate to the presidency itself, it doesn't relate to his time in office, and it's not even directed at the president, so it can't be that much of a distraction. In addition, it isn't a case in which there is actually a criminal prosecution of the president. It's not like the grand jury is only directed at the president himself, because the investigation could relate to other members of the Trump Organization, for example. The second case in this trilogy that's going to the Supreme Court comes from the DC Circuit, and this one was 2-1. And this is out of the House Oversight Committee, and it issued a subpoena also to Mazars related to the president's tax returns, going back for quite a long period of time, saying that the committee was investigating whether it is that federal ethics laws were sufficient or needed to be expanded or modified in some way. That subpoena was upheld by a panel of the DC Circuit, again, 2-1. The third case, now back in the Second Circuit, relates to a subpoena from a House committee to the president's lenders, Deutsche Bank and Capital One, again seeking a variety of financial information, principally tax returns, and also as part of an ongoing legislative investigation. So all of these decisions went against the president, although the Second Circuit decision was 2-1 as well. And the president took them all up to the Supreme Court, which stayed all of the rulings and granted review on a very expedited schedule. And the cases will be argued at the end of March, with the goal, of course, of being able to decide the cases by the end of June and get a ruling, and which would come down, in the heat of the presidential election. So the backdrop in terms of case law for these decisions is the Clinton versus Jones case and the Nixon tapes case, principally. Clinton versus Jones involved civil process in federal court. Of course, the lawsuit against President Clinton by Paul Jones, in which the president was required to respond to discovery and sit for a deposition. So the process was directed directly at the president himself, but it was in federal court, and it was not a criminal case. The second case, the Nixon tapes case, President Nixon was required to turn over the tapes from the Oval Office to the grand jury that was investigating the Watergate conspiracy. And so the president lost both of those cases, and the Manhattan DA and the House committee say, well, these cases follow automatically from those because those are much more burdensome subpoenas that are much more of a direct threat to the presidency and much more directly involve the presidency in allegations of criminal activity, and reject the idea that the fact that there might be some burden on the president is sufficient to create some sort of privilege against the responding to process. Particularly when, as here, the subpoenas that are issued aren't directed to the president himself. The president, on the other hand, makes a variety of arguments that deal very much with claims of burden that do sound a lot like the arguments that were made by President Clinton and rejected about how burdensome these subpoenas can be. In the Trump versus Vance case, the president specifically articulates a concern that this effort to subpoena the president can do two things. One is it can create enormous burdens because there are thousands of individual district attorneys, and he paints a picture of, like, what if you adopt the rule that says that you can issue subpoenas related to the president's activities, and lots of politically hostile district attorneys, President Trump says, would do all kinds of things to distract and burden the president. The second thing the president says is, look, this is contrary to what he believes is the constitutional principle that you cannot indict a sitting president, because that too would be enormously distracting. And the president distinguishes both Clinton versus Jones and the Nixon tapes case on the ground that those at least involved a federal court and federal procedures, whereas here you're dealing with a state court that would be much less attentive to the protections that are applicable to the presidency and to the interests of the presidency and to the possible distractions. When it comes to the House cases, both of the Second Circuit and the D.C. Circuit House subpoenas, the president's basic view is that there just is no legitimate legislative purpose here, that what's going on from democratically led House committees is nothing more than an attempt to distract and burden the president and try and subject him to political embarrassment by getting very, very private information about himself and his family. And the president says that there has to be a heightened inquiry into whether it is the fact that there is something actually on the table legislatively for that Congress is tackling, and there has to be a real prospect that there's actual legislation that's going to be passed. On the other hand, there's an obvious dynamic between these cases and the president's position here and what was going on in impeachment, where the president was simultaneously taking the position that you could not issue a subpoena for close advisors of the president in the course of impeachment, which is a constitutionally denominated function, obviously was being pursued with respect to the president. And so the House committees say that the president is trying to have his cake and eat it too, and say that, just broadly you can never subpoena the president's advisors or private information related to the president. And the House here, of course, again makes the argument that these subpoenas aren't burdensome. They're not directed at the president himself whatsoever. The president doesn't have to do anything with respect to any of these cases, so it's not a distraction to him. In terms of how these cases are likely to turn out, it's uncertain. If you were to put this question to the Clinton versus Jones court, it seems obvious that the president would lose them, because that decision just very broadly says the president isn't above the law. We're not that concerned about distraction. If there are too many of these cases or too much burdensome discovery, the courts can step in and fix that particular problem, but there isn't a broad presidential immunity. On the other hand, in the wake of Clinton versus Jones, there's a broad sense that that decision kind of radically underestimated the prospect for distracting the president. That these cases can be much, much, much more of a pain, much, much more of an effort to divert the president from doing his job, which is incredibly weighty and requires enormous attention. Nonetheless, I do think that the distinctions that are drawn by the House and by the Manhattan DA are likely to be successful. These cases aren't criminal prosecutions directly of the president. They aren't subpoenas directed to the president. They don't involve any activities of the president while he was the president. They don't involve any privileged communications of the president. And so the president is left essentially in a position that seems to be he's just entirely unique and is not susceptible to civil process or criminal process. And while there are some justices of the court that are very pro-executive, Justice Kavanaugh, as Kevin talked about from the CFPB case and other things, has really indicated that he thinks that the presidency deserves and needs special protection. I don't think that there's anything like a 5-member majority on the court for that. Certainly, the 4 more liberal members of the Supreme Court aren't inclined to have such a strong view of executive power, and it would be surprising to me if they couldn't find a 5th vote. That doesn't mean that the court's opinion won't acknowledge the interests that are at stake, as did the Clinton versus Jones case and the Nixon tapes case. The Supreme Court in those decisions has a lot of language about needing to be attentive to the important role of the presidency and the potential burdens on the president, but in both instances rejects the kind of categorical rule that President Trump asserts here. So, does that mean that the cases aren't a success from President Trump's perspective if he loses them? No. He has managed very successfully, and his lawyers have managed to hold up enforcement of these subpoenas for a long time. Even if the subpoenas do go out and are complied with in July, it's not clear that there would be any effect at that point on the election. Certainly, the Manhattan DA says that the subpoena there will be, the information that's provided there will be kept entirely confidential because it's going to the grand jury. The House committee materials may well end up being released, but, very, very late into the process of the 2020 election. So the president, in litigating the cases all the way through the Supreme Court, may be getting essentially what it is that he's looking for. But it would be quite surprising to me that he gets the kind of ruling that he wants, even though he, leans heavily on the fact that he has appointed multiple members of the court and that it has a conservative majority now.
Thank you. In the interest of time, let's move on and do 5 minutes on the faithless electors case, and then spend a few minutes talking about some broader trends.
Sure. So, on the theme of an election, just to remind everybody, you don't get to elect the president. You get to vote for a slate of electors who have promised to vote for the presidential candidate that you prefer. And so the question in this case, there's actually 2 cases, is whether those electors can be removed if they don't keep that promise or punished if they violate it. So what happened in a couple of cases is that Hillary Clinton won the popular vote in Washington and Colorado. A couple of the electors in those states, nonetheless, attempted to or did cast their vote for somebody else. Colin Powell, Elizabeth Warren, Susan Collins, a cast of people. And in Colorado, that got caught, and they replaced that elector with somebody else who voted for Clinton. In Washington, those votes got forwarded to Congress and got counted. Didn't change anything. But later, the electors were subject to fines. And in the appeals from those decisions, the Colorado, the 10th Circuit, which ended up in the Colorado case, said that violated the Constitution, that the people who cast the votes in the Electoral College have a constitutional right to make up their own mind, regardless of who they were pledged to and regardless of the popular vote in those states. And the state of Washington said, no, there's nothing unconstitutional about making people adhere to those promises. At issue in the case, a big question in the case comes down to an interpretation of a 1952 case called Ray versus Blair, in which the Supreme Court said it's fine for states to require electors to pledge to vote consistent with a popular vote or with the party that they're affiliated with. They didn't go so far as to say what would happen if it's constitutional to punish them or replace them if they don't. The states say, however, it's a very small step from Ray to doing what they did in this case. The electors make an originalist argument where they say that there was some evidence at the time of the founding that a lot of the founding generation thought that the electors would be exercising independent judgment in selecting the president, and they see some indications in the 12th Amendment that the ratifiers of that amendment also viewed the electors as acting in the capacity as federal officers, exercising federal functions that is outside the purview of the states to regulate. They suggest that maybe Congress could do something about this problem of faithless electors, either by not counting their votes when it comes time to tally the Electoral College votes, or doing something else perhaps. Just as an aside, the elephant in the room is, what in the world sense does the elector's position make? It's sort of crazy to think that we go to the bother of having a popular election to pick a bunch of people whose names are frequently not even on the ballot and let them go and just decide who ought to be president. And that, interestingly enough, is a view that seems to be shared at least by the lawyers for the electors, who have kind of forthrightly said that if they lose this case, that's not so, or if they win this case, that's not so bad, that it makes the system crazy, because what they're really interested in is getting rid of the Electoral College entirely.
Well, let's talk about that for a second. How much do you expect broader critiques of the Electoral College to factor into this debate over these particular state laws, if at all?
I have a hard time imagining any justice who thinks that the Electoral College is a bad idea, thinking that we ought to make it worse by ruling the electors. So I think they're going to have a very hard time getting, honestly, any votes in the court. It's possible that there is a decent originalist argument that at the very founding, before we had political parties, that maybe it was contemplated that we were not going to directly elect the president, or even kind of indirectly do it. We were going to pick these people who would pick the president, but there's been a lot of water under the bridge since then.
And how do you think the justices will respond, particularly Chief Justice Roberts, to being brought so squarely into the middle of such a political question?
Well, I mean, my sense is that this case will only be seen as a big political thing if they rule in favor of the electors. I think that if they simply say, no, it's fine, you can make them keep their promises, so that the popular election means something, it's not going to be viewed as the court being particularly political, which I think is what they're going to do.
That sounds very likely. Okay, we just have a few minutes left, so let's take a step back, and I'd love to hear from each of you. Just kind of you're in the thick of it. Many of us are viewers from the outside, watching as much as we can. What are the most interesting trends you're seeing, both this term, but also kind of taking a step back in general, sort of the direction that the court is taking now with, the current political climate and the new members of the court?
So Espinoza is a good example of a revival of interest in religious freedom, including, there are other cases that I think you probably talked about last time, about the extent to which that allows religious institutions and religious folks to get an exception to otherwise generally applicable laws, or to get what some view as equal treatment, or others might view as special treatment that other non-religious entities don't get. That seems to be a project the court's taken a ton of cases this term on, and probably will continue to work its way through in the next few terms.
And I would say the thing that will be really interesting to me is, in recent terms, particularly last term, the court has kind of shied away from a lot of the big hot-button issues. But this term, with the cases that we just talked about, with the gun rights case we talked about last time, and several others, it has, stepped much more into the thick of things. And previously, the court had seemed kind of to have a broad level of unanimity. And also, there were a variety of cases in which the court's conservative members splintered, giving the former liberal members of the court a 5-justice majority a couple of times. Justice Gorsuch went over Justice Kavanaugh, the Chief Justice. And whether it is that with these this higher number of hot-button issues, you're instead going to see the classical 5-4 conservative progressive alignment. That's, I think, the big question is, how rigid do if you call them blocks on the court become, or how much, of the kind of flexible dynamic is there? In the same way, there's this interesting phenomenon that it is actually the former liberal members of the court that have kind of stuck together more rather than breaking apart, and whether it is that on some of these questions, for example, religion, that even they find divisions. It'll also be interesting to see how many of these cases are just serious overreaches. Like, I suspect that the presidential subpoena cases are, overreaches by President Trump in trying to find these sorts of immunities from civil and criminal processes. It may be true of faithless electors at all. And so some of these cases that seem very, very sexy and very ideological may end up being actually pretty easy in the Supreme Court. Then I'm also interested to see how many of these cases really set the foundation for just fundamentally reworking a lot of how we think about the government. The CFPB case's potential is massive, both potentially 1/3 of independent agencies that have a single member director that's not removable for cause. But that case sets the table potentially for a broader reassessment of the constitutionality of independent agencies to begin with, and whether it is that we have a real sense of what's called the unitary executive, and the president just there isn't independence. The president's going to enforce the laws. The president announced on Twitter the other day he's the chief law enforcement officer of the country, and that he has control over all of these sorts of things. And so too, as Kevin suggested with respect to the Espinoza case, you could be really looking at a reworking of the separation of church and state. So we may be talking about this term for many, many more terms to come.
Well, thank you both so very much for the thoughtfulness and all of your guys' work on these important issues. Just a few kind of concluding remarks. It was really a pleasure and an honor to host this conversation. I encourage all the viewers to continue to follow these cases on SCOTUS blog as the term progresses. As Tom and Kevin mentioned, we have a few cases that are going to be argued in the next few weeks, and those will be particularly interesting. For CLE credit, if you indicated in your registration that you're barred in a state for which credit has already been approved, you'll receive your CLE certificate by email in the next month. We'll also follow up by email with information about credit in the remaining states. We also have other CLE programming at Casetext, including a 3-course advanced legal research certification program, which I know is of interest to many litigators. So go to casetext.com/CLE to learn more about that program. And then as a quick note, Casetext is really thrilled to partner with SCOTUS blog. If you're not familiar with Casetext, we provide free access to cases, statutes, regulations, rules, and other legal materials to lawyers and the public, along with very advanced legal research technology to over 5,000 law firms and some of the country's most accomplished litigators. We're within days, actually, of announcing some pretty exciting technology that will change how many attorneys draft motions to the courts. So this is a very good time to follow us on Twitter or get on our mailing list. So to learn more, please do reach out to the team anytime at contact@casetext.com, or just go to casetext.com to learn more. Thank you all for your time, and thank you very much to Kevin and Tom, and everyone have a wonderful day.
Thanks so much.
Thank you.
That's another episode of SCOTUS Talk. Thanks for joining us. Thanks to Casetext, our sponsor, and thanks to our production team, Katie Bart, Cal Goldie, and Edith Roberts.